Bray?
Okay. All right. Good morning. Today
Partner in crime should be
is April 5th, and this is the second half of the morning session of Senate Natural Resources and Energy. We're continuing our work on anti-degradation and the associated statute and rule on the topic. So we have, I'm going to pass them out now.
Yes.
Copies of language from Mr. Overstreet, and if you can introduce this to, have you, do you have copies?
I do.
Great. I'll make sure. Also, I realize that we might be short. And then the second document is recommended edits to 10 VSA 1973. So, oops, sorry.
They're on our website. They're on our website.
Okay, great. Thank you, Jude. Watson here. So I think I gave away one too many. So with that, maybe you could just for everyone in the room and for anyone watching and looking at the documents, if you could fill everybody in and what we're looking at and what versions of things that we're working with here. So
Absolutely. For the record, and good morning to everybody, members of the committee. Thank you again for the opportunity to testify. My name is Mason Overstreet. I'm a staff attorney with Conservation Law Foundation Vermont. I'm with
John Grodman on the policy and water program director for the Vermont Natural Resources Council.
And I think for context, I can quickly explain the two documents in front of everyone. And then John would like to provide some kind of opening remarks and context on the kind of intent behind some of these recommendations. And then I can walk the committee through each one.
and
So
then
you,
just for work for the balance of the morning, my hope is that we'll walk through, we'll get the context, we'll walk through, get some detail. Things will emerge in that discussion that are not perhaps resolved between different parties, and we can flag them. Some of them we might be able to resolve here and now. Others might get flagged for further discussion, but I'm hoping that we'll start to, in my tendentious phrase, paint ourselves out of the room and get more things agreed upon with a goal of being in agreement and voting it off. Right. Okay, so back to you.
perfect. So committee members, there are two documents in front of you. The first document is for logistical convenience and ease. We, last Thursday, the recommendations which we orally testified and presented, we inputted into in-text recommended edits to the draft committee bill. Now, as far as drafts go, Mr. O'Grady's draft was in PDF version, and because it's closely similar to the agency's existing draft, we opted for technical reasons to mark up the agency draft, which is Mrs. Smith's draft dated March 15th, 2023. They are nearly identical, but that's something to flag for Mr. O'Grady to ensure that they correlate.
All right.
The second document in front of you,
Well, that's going to be helpful because that we'll see some agency edits as well as the ones you're proposing.
this document only shows our track changes
Right.
and suggested edits. It was the latest version from the agency.
Right, and so I think once we finish, maybe we can come back to Ms. Smith and you can highlight what is new from the agency side. So we can identify edits that are all leaning in this one. Or that make sense?
Yes, Chair.
Great.
The second document that you have in front of you, again, for kind of logistical convenience and ease and to avoid confusion with what I'll call the master draft, are recommended edits to Title 10, Chapter 64. And this was that kind of into the weeds recommendation regarding the engineering presumption to licensed certified engineers for wastewater systems. We opted to keep this separate again, but if, you know, our recommendation is that it be folded into the master draft at some point.
Okay. And I think, you know, so my blunt way of thinking about this one is that not all engineers are not created equal. And so it may be that a second level of review will be helpful to the permitting process. So I haven't offended anyone, but I think that was the way I heard it. So, all right, so I'll put this one aside, Senator White.
Thank you, Mr. Chair. I just wanted to lift up what you were just saying. I also agree with the addition of having oversight from ANR in this topic. And are you hoping, as we hear this testimony, for us to signal where we would like to recommend the committee consider amendments to the bill as it stands, or what process would you like to follow?
Sure, so let's go through what we have,
Okay.
and then but while we're passing through something, if you have something that you want flagged, let's mark it while we're in process, then we get more and more edits into the document. And then hopefully we do a next iteration of the document in the next 24 hours, for instance, and have a more mature thing for us to look at downstream. Senator Watson.
Thank you. I just want to make sure that I'm understanding these two documents. So we have
This is our drafting request.
this is the drafting
Edited.
request. Okay. And then the other document, these are additional recommended changes that you would like to see added to this document?
Correct,
Okay.
Senator Watson. So this draft
Yeah.
is the master draft right now. What is the draft reclassification bill? It's almost identical to Mr. O'Grady's, except the agency drafted it and due to format, you know, technical reasons, we opted to mark up the
Okay.
agency draft.
Okay.
This document is our recommended statutory amendment changes to Title 10, Chapter 64 regarding the engineering presumption issue.
Yeah.
And again, because it is a separate section in law, just to avoid having a lengthy master draft, I just personally opted to keep it on a separate.
Okay. Okay.
So it's not in this version. And then we have the
Right.
discussion.
But we
for possible
could-
inclusion.
Yes.
Add it. Okay.
But between the two documents, our 5 recommendations, which we testified about last week, are in text in both of these documents. So with that, I think I'll pass it to Mr. Groveman to provide some kind of introductory remarks.
Great, thanks, Mason. So I just want to be really clear, you know, about our position and kind of how we view this issue, and then we could dive into the details of it. But so this is not our proposal. You know, we worked through the anti-deg rule and think it's a big step forward. As we said, we have some, you know, items we'd like to have added to that rule. We're working through the rulemaking process separate. That's not this legislation. You know, I look at this as similar to like when I came and testified about S100. You know, we came in, we said, we don't think we should be like, having these Act 250 exemptions at all right now. But if you're going to do this, this is how you could do it in a way that we think would protect the environment, and we could move forward. And this is very similar in that this is not our proposal. And you know, in our perfect world, we'd be reclassifying the waters based on the data, and you wouldn't have to actually lift the 1,000-gallon limit. We understand the agency's arguments. We understand the difficulty that they experience in the reclassification process. And so we said all along, okay, if you're going to do this, you know, here's the way we think we could do it. And actually, all of our most of our recommendations are really about dealing with the wastewater issue and protecting. If we're going to lift the limit, we need to have the protections. So the Title 10, Chapter 64, second document is super important, right? Because that's directly related to wastewater. And if we're going to lift this limit, you know, we're saying we need to really have a different approach to wastewater, on-site wastewater permitting in these very high quality watersheds, Class A and Class B1. That's sort of the really important meat of the recommendations, as Mason goes through them. The other recommendations are.
Word of the day is begrudging, right? We've heard that earlier this morning, so.
Yeah, I just want to be clear, like where we are, just like,
Yeah.
every people are watching this, like, you know, and throughout, I just want to be clear that this is not our proposal, or we're not. But we are just, we want to move forward. You asked last time, is the status quo acceptable? No, it's not. You know, it's not acceptable. We're not classifying waters. We're not moving forward. We want the anti-deg rule to move forward. It is an improvement. So that's the spirit in which we're here, you know, today. And I just want to be really clear about that.
Sure. Okay, thank you. Senator Watson.
Would reclassification happen? So reclassification would not happen if this bill didn't move forward?
Well, the agency is in control of reclassification, so, you know, we could file petitions, you know, and then require the agency to act on those petitions. Last time a petition was filed by people in Ripton for, I think, 3 waters. It took over a year, definitely at least a year and a half, to work through issues raised by neighbors being concerned about, you know, what is this going to mean for development restrictions? And it did move forward ultimately. That was the first petition, you know, in a long time. I don't really remember if there's another one that probably was like a long time ago. So it's not happening. So regardless, like whether I think that the agency on its own should move forward with classifications based on the map that they showed the map that shows the waters that are candidates based on data. Like if I were king of the world, which I'm not, I would say just do it, just to move forward with the classifications based on that data. But what we're hearing from the agency, if this doesn't change, they're not gonna do that. And so if there's a way to protect the waters from wastewater degradation once the ban is gone and move forward, that's the spirit in which we're here. Does that make sense?
It does.
Sure.
So I just want to be clear because I think it gets muddled sometimes. And we talk with everyone and want to work with everyone, want to be constructive. And just like with S100, you know, I appreciated this committee's work on it. I think you made it a vastly better bill from our perspective. Would we have written it that way? No, we would not. But, you know, so that's what legislative process is, right? It's compromise and, you know, different viewpoints. But I just wanted to be kind of clear, kind of like how we've been engaging on this, you know, all along, you know, and this really wasn't the focal point of the stakeholder group. Just kind of, it was a side issue and it was always there. And then once the session started, we started to see, you know, we saw Representative Sims has a bill in the House. So we talked a little bit about that, but that bill didn't go anywhere. So anyway, so the wastewater recommendations are super important, and Mason can go through the details of those. There are recommendations about the issue you had a really good discussion on about non-point source pollution. That's the ag pollution and forestry logging pollution, which we do have a disagreement about how robustly those issues are addressed in the anti-degradation rule and what permits are covered and what, like this was the discussion that you all had, what discharges are covered, what isn't discharged. We could have a debate about whether a tile drain is a discharge. I think Mason and I would argue that it is a discharge and it should be covered. But anyway, that's with what this work group, if we're going to move forward with this legislation, let's put a provision in the bill that allows us to have a discussion to try to move that issue forward, because we're not going to protect our high quality waters if we don't actually try to address agricultural and silvicultural pollution from logging operations. So,
well, I appreciate the spirit in which everyone's been working. Like, no one is entirely satisfied with what's being proposed, but it seems like, to me, the good news is that there's an opportunity to make meaningful progress, especially on the reclassification that ends up bringing 100+ waters.
yeah, but we understand and we appreciate what's happening, but I just, just wanted to be clear.
Yeah.
We have members and supporters that don't want to see the 1,000-gallon limit lifted, so we're not legislators and elected officials, but we also, answer to the people that we represent and who support us. And so we hear that,
Yeah.
so that's so I wanted to say that publicly. 'Cause-
Yeah, you get your own version of pink slips.
Yes, yes, you could say so. We don't have pages.
Okay, great.
Yes.
Well, thanks for that.
And Senator Watson, I'll just quickly provide one more thought onto what John said and just reiterate, we share the same goal. I think all of the parties share the same goal of the named problem of reclassification generally, the need to classify and reclassify certain waters so that they receive their deserved protections. Our position here again is that anytime we are looking under the hood at a policy that has proven to be effective, and in this case, there is no denying the 1,000-gallon per day prohibition has been effective at what it was intended to do. Our position and recommendation is tread lightly. We are not denying or arguing with the agency's position and observation and assumption about basically the chilling effect that the prohibition has had on classification. That's certainly true, and this committee has heard, from other stakeholders regarding that. And again, that is why our recommendation is if the legislature is to move forward with lifting the prohibition, let's ensure that equal or more robust sideboards are put in place for what is now existing prohibition in law. So with that, I think if there are no further questions, I can jump into in-text recommended edits. Okay, so I'm first looking at the separate document, which I'll just deem, it's Title 10, Chapter 64, which includes this engineering presumption issue. And if you look to page 2 of that document, you will see two recommended edits from our organizations. The first is a qualifier at the top of the page, where basically we qualify, that we are discussing systems in what we deem very high quality waters. As Mr. Laflamme and Mrs. Sargent mentioned, these are B1 and Class A waters. So that's a relatively minor change at the top of the page in track changes. Is everyone seeing that?
Yeah, I'm not.
Page.
So I'm on page 2 of not the master draft classification bill. I'm on the Title 10, Chapter 64.
Okay. You got it?
So this is a relatively minor change. Again, just to be clear that we're talking about the same thing. The main part of our recommendation regarding this presumption and deference that is given to certified licensed engineers, as we testified last week, the language which we are suggesting lifts that and allows the agency to have kind of authoritative review of these wastewater systems in very high quality waters. And I think with that, if there are no questions, or yes.
Years ago, I was involved in that particular provision of law that the engineer gets to authorize and approve his or her own work. And the argument was that they were doing it in jeopardy of their license. And that because the license continuation of the license depended on them not authorizing bad work, that this would work fine. This was one of many times that I have voted for something. I wondered if I was doing the right thing.
Yeah. I mean,
Was this a mistake?
I think that's, that is a common sort of regulatory theory. I was with A&R when this change was made, and I had to rack my brain about what was going on. And I think what was going on was, based on my memory, is there was stress on the budget. They were making cuts to certain programs, and they wanted to basically be able to operate without, as robustly, of a A&R wastewater review program. And so this sort of engineer certification allowed the government to use less resources, because you were basically giving the strong presumption to the designers under the theory that you just articulated, and which I don't think is true. You put your license on the line. All we're saying is, I can't speak to how well the program has worked, statewide. I haven't seen an audit of it or a review of it, although I'm sure there has been one, and if not, there should be one. But we're just saying, in these very high quality waters, let's be super careful. And I'm sure that the agency does some sort of look at the design as it comes over from the engineers, but let's not give them a presumption, like, just in these high quality waters. And I want to be really clear, because this is, I think, a misunderstanding with the agency. We're not asking the agency to design these systems. Still, you'd hire an engineer to do all the design, do everything that they would do in an ordinary circumstance. They just don't get that legal presumption. They just start like even. They do the design, they do the work, they hand it to you, you're at the agency, and you're not giving them any presumption that this is okay. You're gonna go through it, make your own decision that it won't degrade these very high quality waters, the class A and B1 waters. So
You don't get to grade your own paper.
yeah, let's make it even. This is the way I look at it. The presumption puts it up here. The design is, it's up here, and you're assuming it's up here. Let's make it even. Agency just looking at it straight up, and
Okay.
we're lifting the 1,000 gallon limit. We're allowing these systems to go forward. Let's just have the straight up, even review.
I like this better than what I voted for.
Senator Watson.
Thank you. So just looking at this first change, so this is in a section that is about variances for technical standards for replacing a system, right? And so the proposal is to add that you can't get a variance for not meeting these technical standards if you are near these high quality waters, basically.
Yeah, that was the idea.
My question
Yeah.
is about the word near, because near could be, it's kind of a relative term. Do we, like, if you're in the watershed, you're in the watershed. And,
Yeah, I struggle with that word as well.
okay,
All the time. And your question, I think, when we started this conversation, was what does it mean to be in?
yeah,
And I think I had proximity, I had all kind of synonyms. You could say, I would class A watershed, although I'm not, I guess, then maybe delineate like the watershed of the class A water, and that, you see here, it could be a wide sort of,
yeah,
area. It's a fair question, and maybe ask the agency how to best define
Okay.
that. But I think it's a fair question, and I struggle with it.
fair
as
enough,
well. Yeah.
fair enough, thank you.
Okay, well, since we are trying to cover the basis and make progress while we're working, Mr. LaFawn or Ms. Sargent, do you want to comment on the near versus in a watershed?
Thank you, Chair Bray, and I agree with what Mr. Groveman was just saying, and Senator Watson as well. I think in a watershed up is more conclusive, more appropriate than near.
Is that work on your side?
Yeah, absolutely. Like I
Yes.
said, I struggle with how to characterize.
See that? I just put a check next to that. All right, we're making progress. Let's go back down to no legal presumption language at the bottom. Oh, sorry. There wasn't anything more.
Oh, no, that was it.
Great, thanks for the eagle eye.
Chair Bray, I'm sorry to interrupt. We do have other comments on this language in general,
Oh, sure.
but as to this one issue, we agree that in a watershed.
Yeah, I'm not trying to coerce anyone to anything, but I figured, well, at least I'll mark what we're agreeing on while we go.
If you had to, this is what you would.
Maybe if you agree, maybe we revisit this, since it sounds like the agency has suggested language.
Okay.
Oh.
So you'll have new language that addresses the no legal presumption issue.
That's correct, Chair Bray.
Okay. And so I'll put that
Yeah, I mean, it might be helpful just to see the different, like, we haven't seen that language, so.
Is that, so let's also figure out the workflow process here is, do you already have such?
I'm happy to discuss the concept and we could easily throw together the language as the limitation on this particular concept.
Okay, I'm gonna just put down, ANR has new language, and so when we do the next iteration, I'd ask you to include it in that, all right?
So it'd be great, maybe if, outside of, you could just like share, we could sit down and just like go through it. And, I think that would probably expect from just the parties, so to speak, view, and then we might be able to present something that we agree on, or something that we agree on except for like 3 words or something.
All right, even better, so if you all can powwow and then bring.
Yeah. So you agree, Mason?
A resolution
more efficient.
forward, that will help.
I
Okay,
would like to just, before we leave this, just to summarize the point that again, personally, while I believe in the reasonable person standard, like the rationale behind our suggestions is that, unfortunately, not all engineers are the same. And, this again is a belts and suspenders approach and a precautionary approach in what we see as very vulnerable, precious waterways, especially in a time of climate change. So with that, we can transition to the other document, which is the master draft of the reclassification plan. And we can begin on what is page 2 of that draft. Is that this document? Yes. Yes.
and if it's for anyone who's trying to do this remotely, it is the draft that says page 1 of 7, there happens to be an edit called out, says style definition, bill title on the right, and it's 7, anyway. Makes it easy to identify.
Yes,
your
and thank you, Chair Bray. And again, for the record, this is the agency's draft last dated March 15th, 2023 by Mrs. Smith. Okay, so on page 2, in our organization's opinion, it's our recommendation that the findings were fairly lengthy and not necessary. And so you will notice that we performed strike through on a pretty significant amount of the findings. And again, the rationale is our organizations would like to see what some of those findings mentioned in law, subsequently below. So some of that language you will see below, but I just wanted to flag that.
Sure. The Senate tends to be more terse than the House on findings. Oh, different deal. We don't, sometimes there are none. All right, so onward.
But if there are no questions, we can transition to page 3.
Well, so 7 and 8 are simply struck, but then 9 becomes 7, and you're striking, some of it's in red, so you're striking the opening sentence, and then you're proposing that it begin with thus the secretary shall propose to reclassify, and leaving that as a finding.
Yes, Chair Bright. To my point, when I first introduced and provided some context after Mr. Grove, and we do think it's important that there is language in the findings regarding the need and the point that the secretary shall reclassify waters where water quality data meets or exceeds the minimum criteria. We believe that's an important point to reiterate, and it appears that all parties are in agreement on that.
Okay, so let me just check in with Team ANR.
It's a wording change that we would suggest there, rather than the secretary shall reclassify. We would say the secretary shall propose for reclassification, because it is a rulemaking process.
It does have that.
Okay, perfect.
Okay. So with shall propose reclassify, we're in sync there. Okay. And as you said, you're editing Ms. Smith's last draft. Okay, great.
Yes.
Thank you.
Okay, so moving along, we are now on page 3. You will see a few more strike throughs at the top of the page. And if there are no questions on those strike throughs, we can transition into law, into some of our core recommendations.
Okay,
Okay.
let me just check, yes, everyone's ready to go.
I'm now looking at section 2, which is 10 VSA 1259D, and we are proposing that be amended. If you look at the bottom of the paragraph, starting kind of in the middle, actually, I break these points up into 2 recommendations. The first is basically the amendment of the, let's call it the middle sentence, which basically qualifies that on-site disposal of wastewater, from a system, from a wastewater system with a capacity of less than 6,500 gallons may be permitted. And we inserted, within a class A or B1, so very high quality waters. And then we qualified it that 1, it comply with the requirements under 1263F, and 2, again, belts and suspenders, that an individual permit is received, including a cumulative impact analysis. This was previously discussed when the agency, gave a flyover of the rule. The anti-degradation rule does include and require individual permit review in very high quality waters, which includes a cumulative impact analysis. We think clarifying it in law is also helpful.
Okay. Can you please remind us, or at least me, of 1263F, the citation that we're referring
I think we're gonna get to it, just below.
Okay.
We'll walk through it.
Yeah, that's exactly right. It is directly below this, so we are going to discuss 1263F.
So I'm going to pause while we're passing through. Is A&R okay with this proposed change?
We're okay with the concept. Again, we have alternative language that we would like to recommend here,
Okay.
modifying that a bit.
Okay, so I would ask then that as part of your discussions, you.
Yeah, that makes sense.
Okay.
Senator,
Ms. Smith.
Mr. Chair, sorry, we can really briefly, explain those sort of the proposals that we have. I don't know if that would be helpful, as opposed to sitting down and coming back with language. We have looked at the language and we have some comments on it that we can share with you now, if that would be helpful.
You mean point by point on these? You have language with you that addresses, that is a counter proposal sort of to this.
Yeah, and as opposed to walking through actual language changes, I think there might be some value in us just introducing sort of the ideas that we have that we'd be proposing modifications to the language.
Sure. I mean, whatever helps us keep on.
Right, maybe we could just we're almost done. We could just go through, and then I think it would be helpful for the agency to,
Yeah.
if we have time to hear about it. But, obviously, everybody, including especially the committee, needs to look at the specifics of it. I did want to make a point, because I thought you had a really good discussion about cumulative impacts.
Yeah.
Earlier, and Senator White, I thought you made some really good points. And that discussion kind of triggered in my mind, this proposal that we have, we hope that with cumulative impacts, like in this situation, where you're looking at multiple wastewater systems, that there is a different approach than that typical approach, in that, if you get to the 4th system in Class A water, that is, over 1,000 gallons, that wouldn't have been allowed previously, that there is some sort of contemporaneous examination of okay, before we let this 4th one in, where are the other 3? Are they related in terms of the soils and where the waste is going? And, has there been an impact on the water? And none of that, we're not asking for any of that in the bill, but I just want for the record to say that I think that because these are the very high quality waters, that we, in writing those words, cumulative impact, that we have a different vision for how this will get implemented from, this discussion earlier in the morning in terms of how cumulative impacts are generally handled. So
Okay, so, yeah, I think want to come back to that one in that, we talked about, were you assessing permit by permit by permit?
Yeah.
Or was it that you were monitoring water quality,
Right.
body of water, and then saying, we've now come close enough to a lower limit that we're
Yeah,
concerned about
I
further
don't
discharge.
dispute, because there's so many. I think the way the analysis was described is my understanding of how it works now, but I think these are just for wastewater systems, but it's related to the lifting of 1,000 gallons and in these high quality waters. And hopefully we're not going to see like rampant development, right, in these areas that would put at risk the waters. But anyway, those words are really meaningful, I guess, but my point is that they're not.
All right, so let's keep going and then, maybe it's, Ms. Smith can join us at the table. We can go through the same draft and, or anything else you have with you, and we'll hear from ANR about this draft. Okay.
Okay, thank you, Chair Bray. So starting off again, this was one of our strong recommendations when we testified last week. And this is what we would deem that there be an explicit prohibition against wastewater systems with indirect discharges in very high quality waters greater than 6,500 gallons per day. And so the lines that I am looking at now are lines 19 through 21 on page 3, where we amended and deleted some of the existing language.
Just like a brief, so 6,500 gallons, the reason that is the number is because, and I think you heard of this last week, that's when you go from a garden variety on-site septic permit to these more complex indirect discharge permits. There's a whole separate permitting program for these larger systems. And we felt like if we're lifting the prohibition on sort of the smaller system, we still wouldn't want to see, a larger system that could serve, significant development. That's where that number comes from, just so like we didn't make it up. That's our rationale for the threshold.
Okay, so the trigger from on-site wastewater system to septic system, whatever, wastewater system to.
Yeah, from on-site septic to with indirect systems, as I think Pete said last week, they're all indirect, but there's a separate permitting program for indirect discharges that are above 6,500 gallons.
So what's currently going on for systems between 1,000 gallons and 60?
They're prohibited right now in these Class A waters. Anything over 1,000 is prohibited.
Can you get an indirect discharge permit?
You can't, not for these waters, but generally statewide, like if you want a permit to build a system that has the capacity of one system, 6,500 gallons per day, you go through a separate, more intensive permitting program, basically, for those.
So what happens to the 3,000 gallon a day system currently?
It doesn't go through that indirect district, it goes through the on-site program.
And I would just add, as Ms. Smith articulated last week, there are two separate rules, which John is referring to, which involve separate individual permitting regimes, and the threshold between those is 6,500 gallons per day. But what we were talking about is, again, the 1,000 gallon per day indirect discharge is in a Class A water, so it's separating Class A water from, B1, B2 waters.
Yeah, and then the question in our minds is like, do you want some upper limit on these larger systems and these very high quality waters? You're lifting the limit we have now. Should we have some upper limit? Under Vermont law now, we make the demarcation between these smaller systems and the impacts that they could create and the permitting review they get in these larger systems. So we were suggesting perhaps we should replace the limit with a much higher limit based on thresholds we already have in the law for these systems.
Thank you.
I'm now turning to page 4 of 7 on what we'll call the master draft, A&R master draft. At the top of the page, this was, in our opinion, a little bit of necessary cleanup from the preceding page and our preceding position. There's a strike through at the end of the paragraph, and there's a qualifier clarifying point regarding existing indirect discharges to class B2 waters.
Next question. Any reason that outstanding water resources are not included in that list?
Yes, I mean, it's a great question. And actually, I mean, as Mr. Laflamme, you know, I personally see those as the most protected, and as Pete said, so like, you know, basically those discharges are not allowed in those waters unless they improve water quality or there's a temporary improvement. And again, I defer to the agency, but like, that's how I always explain it.
Okay, that makes, so they're like held to an even higher standard.
Exactly.
Gotcha.
Like we
All
actually,
right.
we just briefly touched on National Outstanding Resource Book. I used to live in Lake Tahoe. Lake Tahoe is a National Outstanding Resource water. And, but that's always like what I envision in my mind.
Okay.
You know, they are the most protective of the protective.
Thank you.
Okay, so if there are no further questions on that, moving along, lines 12, page 4, lines 12 and 13, we just, again, inserted a placeholder, which would be our recommendation, section 4, which would include the recommended edits on the separate document we discussed earlier, Title 10, Chapter 64, involving the engineering presumption and deference issue. That is where we're recommending that, you know, the committee lodge that issue. Moving along, lines 15, just for context, this is our recommendation for ensuring that the greater reclassification issue and the need for reclassification and holding, you know, ensuring that the agency is held accountable by a timeline and date for classification and reclassification. This is our suggested language for that. And if there are no questions, one on the specific language, and this of course goes on to page 5. So the paragraph continues on to page 5 and runs until line 7. The 2 points that we would make regarding this, if there are language tweaks, are that as the agency mentioned previously, the Vermont water quality standards are revised by a rule every 3 years. There's a triennial, rulemaking for those. Now, there, unfortunately, there is a history where the agency has not necessarily met that deadline, the 3-year deadline. As Mr. Laflamme mentioned, in the past 2 triennial reviews, the agency has met that deadline. But our recommendation would be that there is language basically as a backstop so that reclassification and classification occurs for waters with supportive data, either during the triennial review or 3 years after the last approval of the rulemaking for the Vermont water quality standards. Again, it's kind of a check.
On page 4, line 21, secretary shall reclassify. Does this need to be a shall propose to reclassify again, like the other instance? Because of, I don't know if the secretary has the ability to simply reclassify or has to propose to reclassify.
Yeah, I think you're right.
Good catch.
Yeah, it would be the agency's position that it be written as a proposal to reclassify.
Okay.
We would include those waters in our proposed rulemaking, acknowledging that we don't control the end result of that process.
So I know there's language on that for the other instance, so I'm just flagging my copy.
Yeah.
Watch for that. Senator Watson.
Just so I understand, so who does have control of the end of that process?
The agency proposes a rule and then when we receive comments, the rule can either be rejected by ICAR or it can be rejected by LCAR. And
Okay.
sometimes we do have to make amendments to our proposal in order to move it through the process.
Okay, thank you.
And for the record, we would be okay with the amendments that Mrs. Smith just proposed. And that's a great catch.
And then the second half of that block, page 5, like line 3 to 10, is a sort of a belt and suspender provision around in the event that it doesn't occur. So let me check in there with A&R. Is this sort of backstop provision acceptable?
It is an acceptable provision. There's a bit of a chicken and egg approach there in that the way we reclassify is to promulgate the water quality standards. So it's, if we don't promulgate the water quality standards, we will promulgate the water quality standards. So it's a bit of a chicken and egg there, but we could move forward with a reclassification. We could move forward with an amendment to the water quality standards that only contain reclassification.
Yes.
Yeah, that's what I was thinking, right? It wouldn't be the full triennial review of like a whole series of changes, right? That's how I read it. It would be, okay, if you don't do that, then at least just
At least
propose to amend the standards to reclassify the water.
Okay,
and we start thinking of it to do that.
all right.
That's great.
Does that work for everyone? Okay. And then on line 5, we get a proposal to, as opposed to just shall reclassify, right?
Yes.
Sarah Watson.
I have to admit that I don't understand that sentence that starts on line 3. In the event the triennial rulemaking does not occur. Can you just re-explain that? Sorry.
Yes, this was our kind of rationale. So, previously I mentioned that the agency doesn't always meet the deadline
Right.
for the revision of the Vermont water quality standards, which occur every 3 years. So
Right.
this is basically saying if that doesn't happen, the agency is still going to move forward. And we agree with Mr. LaFawn's, suggested amendments on that, that this would basically be an amendment to the Vermont water quality standards versus the full triennial review.
So it'd be a targeted amendment. The triennial review really connotes like this, a real like holistic look at the standards and updating of them every 3 years to look at changes in federal law, other issues that have emerged. And you sometimes, that doesn't always happen. As I've said, the agency's been pretty good about this the last 2 cycles. But when I was the director of the water board, like we went like 7 years before doing a triennial review. So it happens like that sometimes. And so if that were to happen, like it was dragging on, at least just open up the standards to target proposal.
For that.
Yeah, just for reclassify.
That makes sense.
Yeah.
Thank you. Okay.
Yeah.
Okay.
Okay.
So not a full rewrite, it's just
Yeah, just that
adding
little-
to the appendix.
Yeah, exactly. Just listing out those waters that are A and B1.
Yes. Any further questions? I promise to move along quicker. We're getting close. We're not. I have one other point that is worth making. At the top of page 5 of 7, lines 5 through 7, so the end of that paragraph, you will notice language where it says, or the secretary has received an administratively and technically complete petition for reclassification. We are of the opinion that this language is very important to include because it's language that directly correlates and dovetails with the anti-degradation implementation rule, which was reported on earlier this morning. But importantly, this is the piece that I mentioned last week in testimony, which we feel is a very important step forward, which the stakeholder group agreed to, whereby, if a water has data and say, for example, in a hypothetical, a citizen group, submits a petition with supporting data, that proposed waterway that the petition is identifying immediately receives tentative protection under the proposed classification. So we feel like it's an important piece to include here.
Okay, so if we're including it here, is that, I'm just trying to picture procedurally, if this, what you just said, loops it into propose a targeted amendment to the appendix as opposed to the sort of immediate thing, which I'm not quite sure how that works.
That's a great question. I'm looking at Mrs. Smith. I mean, I see this language as correlating with the anti-degradation rule.
Yeah.
But the rule, of course, will and does correlate back to the Vermont water quality standards. Like I have to compartmentalize in my mind, but I see the Vermont water quality standards as kind of the foundation, and then you have the rule on top.
Sure. But it was mentioned before of something immediately taking effect upon receipt of an administrative and technically complete application and receiving protection as of the date of that you've met that complete petition. And I'm just wondering how that happens if we haven't yet had this targeted amendment to the list.
I think
Or why
yeah, I think what we're
include it.
trying to say, and I'm sure we'll get into like whether there's a better way to say it, but we're trying to say is not only like every 3 years, if there's not a trend review and our proposal to reclassify the waters based on its data that's on its list, but also at that same time, they would do, if the agency received an administratively and technically complete petition, those waters would also go in the batch. And just having said that out loud, I can imagine the agency might say, although they can tell us because they're right here, well, it's one thing to have a complete petition, but we need to, we haven't approved it, so.
I mean, we could say, like in the alternative, you could say in compliance with the anti-degradation rule, because the anti-degradation rule is the trigger, I mean, that's at least how I see it in my mind.
That's correct. And as to what Mr. Groveman was saying a moment ago, that's the technically complete part, is that we would evaluate the data that was provided in such a petition through our data standard that describes the rigor necessary to prove that case. And in fact, most cases, I'd say all cases, the petitions typically use state data that we have collected due to the rigor necessary. It would be unusual for a citizen group to collect the full suite of data to the quality assurance standards necessary. So that's the concept of the technically complete, right, John? Once we reviewed it, vetted it, said, yes, this is good to go, that would get added to the batch as you described a moment ago.
And would you be okay with that, like adding this clause? Yeah, okay, great.
Okay, so then we've
Moving
got
along on things, man.
two triggers then for what goes into the batch. That the 3-year shot clock has come up, and then there's if a administrative and technically complete petitions been received.
Yes.
Okay.
Beautiful. Okay, so moving along, page 5. I'm now at line 9, section 6. And one of our recommendations was, again, belts and suspenders, a very pretty straightforward status report, whereby we're recommending that the agency report to this committee and House Environment and Energy on one. If you move down towards the end of the paragraph, basically beginning at line 17 and below, you will see a list of, it's our recommendation that a report be given to both committees on the effectiveness of any legislative changes, namely this lifting the 1,000-gallon per day prohibition, the number of wastewater system permits and permits at large issued in, again, very high quality waters, so Class A and B1, progress and difficulties encountered on classification and reclassification, again, highlighting that shared goal of most of the stakeholders involved in this, issue, as well as the agency. And that would be it for that. So a status report annually to both committees.
Is there a report already that we received? No, I'm guessing there is.
We produce a biannual report, so our reporting cycle is every 2 years
Yep.
as part of the 303D assessment and listing cycle that's required by by EPA.
Okay, so advances to annual, and then there's more specific data. There's a list of data for the report called out here. So committee questions on what's being requested?
Thank you. So of the items that are requested in this report, just going through it now, one of the things that I don't necessarily see, and I just want to check to see if I'm missing it, is like, because one of the things that I'd be really interested in is I'm not sure how to say this, like places where, like, or how many places saw degradation that was unacceptable. And maybe the answer is none, because that's the rule. Or you know, how much, yeah, does that make sense? Like, just to check on, because the language that I see here is the state of the high quality waters, including where water quality meets or exceeds the minimum criteria. But what about those waters that become impaired? Or
Well, there's already, I mean, A&R is better to answer these questions, but there's already, there's an impaired waters list. That's the 303D list that came up earlier, and that goes to EPA every 2 years. And then there's like, isn't there a list of like waters that are like threatened or at risk or something like that?
When we're evaluating our monitoring data, we look at status and trends.
Mhm.
So there are waters, and typically for our biomonitoring effort for evaluating or assessing aquatic biota, we typically will look at 2 years of data because the condition in a single year may reflect maybe low flow conditions as a result of drought. So we typically will use 2 years of data to evaluate what that condition is. And then we may return to it, you know, in the next 5-year monitoring cycle or in 10 years. And part of that is, you know, we, as I mentioned before, are limited in our capacity to monitor sites. And so we try to prioritize based on activity going on in the watershed, based on, you know, land cover analyses, what sites may be at greatest risk. And then we also do that in terms of being able to predict, again, based on lack of activity in the watershed or based on land cover, what sites could be very high quality waters, and seek to collect data that we may not have been to before in order to repopulate that candidate list.
Yeah, I think it would be hard to I hear what you're saying. I understand
Yeah.
what you're saying, and it makes sense conceptually. But I think it would, like, what we're trying to get out here is kind of be directly related to what we're doing in the bill, which is like waters that we've classified or moving forward on classification, and then especially on the 1,000 gallon, like understanding, okay, we lifted the prohibition. What's happened? Have we seen? You know, how many of these systems have we seen? Yeah, I'll leave it to Pete and Bethany to talk about the monitoring and
Okay.
to get at your question.
okay,
And yeah,
no, that's
So one
helpful.
of-
Yeah.
I would, if I could just add one point, I think we could change like some of the suggested language. If you look at line 13, I mean, broadly, it's kind of this catch-all language on the state of very high quality waters. We could change, you know, it could be changed to status, but I do believe that, like, if I'm hearing your question correctly, Senator Watson, it gets at basically this overarching
Right.
question of what is the status of these pristine waterways? And again, thinking about it, you know, from a lens of climate change and increased, you know, development pressures, et cetera.
Okay,
right. The funny thing is that like once we classify them, then we can zero in on those waters. Like there is the map and the list, but they're not yet right now, as of today, they're not Class A or P1 waters. So once they are, there'll be monitoring focus on them and more information.
so if I'm hearing this right, it's that you're asking about monitoring more broadly, which is addressed by other reports that we're not speaking to here, and that this is a more narrow report tailored to monitoring this change.
Yeah, we tailored it to what really this bill is doing.
That's
All right. Senator McCormick.
How much is reclassification descriptive and how much of it is aspirational?
You have to have the data, so I think it's really descriptive because it's what the waters are.
What the waters
Yeah,
are, okay.
so right now, like that map that we showed earlier, says that there's data that says those waters really are, deserve to be classified based on scientific data as A or B1, so it's not an aspiration, it's like what their
What it
state
is.
is, yeah.
Now, what do we do about waters that ought to be better than they are for classification? Like just virtually their location or the fact that maybe 10, 20 years ago, they were better than they are now.
Yeah, I mean, I'd like to hear the agency answer that question, but I mean, the way it works now is as Pete ran through and Bethany, so the waters, even the B2 waters, if they fall below, as you know, then they're compared and they need to be restored. And we monitor that. If these waters were classified as A and B1, and then they drop below, I think Pete said last time we testified that then they would have to be brought back up, right? So that would be, by classifying them, we would be raising the floor, and then if they fell below that new floor, they'd have to be raised back up, and there would be a plan and.
So like Lake Champlain TMDL.
Yeah, that fell below the floor, you
So we call
know.
We call that the bad list, which requires a cleanup.
Right.
Mhm.
Yeah,
Right.
and we
Well,
do, I mean, that's.
Which leads to my next question, which is, this is all part of the federal Clean Water Act.
Yes, absolutely, yeah,
yes.
we're not making this up.
Yeah, no, I mean, and how the state's role is prescribed by the federal.
Yes.
Yeah,
this is part of it.
As, yes.
So where are we relative to the EPA and to just the federal government? I'm thinking of Lake Champlain, for example, where we have been basically threatened with losing our jurisdiction to the national government.
But that's sort of a separate issue, but we were required by EPA, the state of Vermont, to have this cleanup plan, TMDL, total maximum daily load, to reduce the phosphorus, because that's the pollutant of concern in Lake Champlain, and to meet the targets, and to then see the ecological changes in the water that would say met all the B2 standards, all the chemical, physical, biological standards. And we're required by law and by EPA to do that, to have the plan. The plan is being implemented largely through Act 64 that was passed 8 years ago.
So interesting, but not part of this bill. So let's go on to the non-point source pollution stakeholder group report.
Okay, I will do this very fast. Well, yes, okay, so no further questions on the status report? Okay, while I'm turning the page, I'm now on page 6 of 7, top line 1. And one of our recommendations, again, it is let's call it a philosophical agreement on the extent of jurisdiction under anti-degradation. And for purposes of your previous conversation, I think the relevance is that the Clean Water Act and the delegation given to Vermont under the Clean Water Act requires that the state adopt this anti-degradation procedure. And, the historical context, of course, is there's an interim procedure that was last put together in 2010, but before that, so this is important and relevant. But for here, in regards to some of the conversation about cumulative impact analysis, and some references made to the required agricultural practices and the accepted management practices involving logging, our suggestion, because of the philosophical disagreement, I should state for the record too, that our organizations firmly believe that federal law allows under anti-degradation actually for the state to reach out to certain non-point sources of pollution. We don't feel that's a necessary conversation to have here. And so our recommendation in place is that this draft bill convene a stakeholder group and we kept it fairly broad, but I think a few important things to key in on are line 3 for the creation. We had the Secretary of A&R in consultation, we could say coordination with the Secretary of AFM. And we did not recommend or write out, stakeholder participants or per PM per day, et cetera. It's not a formal study committee. There is a report requirement in this suggested draft language at the bottom, starting on line 16. And I think broad brushstrokes, what the stakeholder group would do, again, is have a healthy, necessary conversation about the effectiveness of these 2 management practices in very high quality waters. So this would be a safe space to have a respectful conversation about the effectiveness of the AMPs and RAPs in what are deemed very high quality waters, so Class A and B1 waters.
Okay. Well, I'll editorialize. This committee, I think, has struggled for years with the distinction between water quality management through Agency of Agriculture and Agency of Natural Resources, given that all waters are contiguous, and it's a little hard to, seems awkward at times to have 2 different agencies managing waters that are connected. So a working group to look at that question about whether or not there's a perhaps more effective way of managing the waters seems like a useful question to put formally on the table.
And in particular, like relevant to this bill, protecting these very high quality waters, and we had the debate and discussion about the effectiveness of the REPs. We've talked less about the AMPs for logging, but as I said the other day, these very high quality water, high elevation, right? Think about where a lot of these waters are, right? They're headwater streams. That's where a lot of logging takes place. We're not, saying that logging cannot occur and protect these waters, but we have a very light regulatory touch right now with logging. We don't really know where logging jobs occur and when they occur for the purposes of looking at water quality impacts. And we think we should have a discussion about whether that should change with regard to these waters. And I think Pete or Bethany mentioned earlier, there's some farms on, in areas where there are B1 water. So we think we should take a look at the RAPs and their effectiveness in protecting those waters.
So let me check in. Well, committee, any questions about the concept of having a stakeholder group?
It's a great idea.
All right, and Senator McDonald?
As I recall, currently, when there were a lot of these projects that are planned and written out, there is no obligation to warn or give a heads up to the foresters that do the inspections.
That's correct.
That they're going to take place.
That's correct. Yeah.
Often they have taken place and been finished before anybody goes to take a look at what went on instead of what's going on.
Yeah, that's exactly right. And we're just saying we should have a discussion about whether, at least in these very high quality waters, we should look at how we administer the accepted management practices and maybe require notification. Maybe the county forester should go out, see what the practices are. These are just ideas, but these are the type of ideas that we would hope would, feed into this group and be discussed.
Major League Baseball, when they have a game scheduled, they also schedule umpires to show up.
There's some people don't like the umpires, but yeah, but that is true. I see your point there.
And Watson?
I would just, under number 2 there, it says, identify whether legislative and administrative rule changes are necessary. That seems like a high bar. And I just recommended,
Oh.
like are the recommended changes. I don't
Yeah, I
know what
like
you
that.
think about
That's a good catch. Yeah,
Okay.
I think right, necessary, just kind of a loaded term.
In the report section, I'm wondering if we want to add a date, because it says upon
Oh.
the conclusion. And I don't know when that would happen. It's helpful for everyone.
We left,
To have some sort of time certain, the route might continue.
Yeah, I think we should have honor before.
we intentionally left that out, but we think that's a good idea. Our idea was to leave it to this committee,
Yeah.
you know, but we believe that that's a good idea to add a date.
Well, maybe as part of your pending conversations with the agency, you could
Pick a date.
talk about what's a workable date. Never want to rush something, but I also want to make sure that we get a timely report so that we do keep our eye on.
Yeah, that's great. Thank you.
Does the agency have any position on the stakeholder group?
We're not opposed to participating in such a group.
Yeah. Okay. All right, great. So, might as well, is there anything more that we need to go through? Just there's a revision on effective dates. That's it, right?
Yes, thank you, Chair Barry. That concludes our recommendations and suggested in-text edits.
All right, great. Any committee questions for Mr. Roman? Great. Ms. Smith, you want to join us at the table and walk us through items that are in the draft of, I haven't done a side-by-side with the earlier language, so maybe you want to talk to us about changes that are already folded into this by virtue of edits that A&R has made. And you're welcome to have as many people as you like at the head of the table. Just keep pulling up chairs.
Do you want to join me?
Sure.
I'll keep it short and sweet, hopefully, because I do think that we saw this proposed language yesterday, and it would definitely be worth having a conversation with Jared, John, and Lisa about whether there's room to compromise on some of the issues. But for the committee's sake, I think it's worth your time to just hear some of the agency's concerns with this newly proposed language,
Sure. That'd be great.
where they occur.
And I do appreciate that everyone's been working on quick cycles, and we're asking you to continue doing that.
Yeah, and I think for individual language tweaks, save that for a side conversation and send you language, but just conceptually,
Yeah.
starting with the proposed changes to the draft bill, which deals with amendments to 10 VSA 1259.
Okay.
The amendments to
Are we
the,
using the longer document or the shorter document?
I believe that one.
The 7-pager. Once the General Assembly finds that.
And we'll read off the master draft.
Yes, that's
Okay.
the one. That's the master draft.
Got
The proposed changes to the findings, the agency is comfortable with those, no issues there. Beginning on, so this is page 3, section 2, the amendments to 1259. The agency, what Mason and John just walked through would basically be a change in the 1,000-gallon prohibition to a 6,500-gallon prohibition. The agency is opposed to this change. We don't think it's necessary. Our position is that the protections provided by the permitting standards under both the wastewater rules, which permits anything under 6,500 gallons, and the indirect rules, which permits any system with a design capacity of 6,500 gallons or more, provide the protection necessary. We think that having this moving target creates confusion around whether or not protection is provided by those permitting programs, and it is.
I'd add that I think it just changes the challenge that we see already in terms of intermingling the prohibition on uses or permitting within a watershed with classification. And I think that it would change the challenge, but if the challenge would continue, and again, as we've testified, that we feel like reclassification should be done on the quality of the water that is, and that should be a reclassification process. And that other issues related to certain size systems within a watershed should be the subject matter of permitting and permitting decisions given the site-specific facts around a particular project that's being proposed and the nature of the watershed, as Mr. Groveman was saying a moment ago, looking at things like soils and slopes and distance. It's I would say impossible to point to a particular system more or less randomly, be it 1,000 or be it 6,500 as being the magic number, below which things are okay and above which things are not okay. But instead, again, classifying, putting waters into their buckets based upon their classification is our proposal, that this would allow us to move forward and sort our waters and provide the protections that we spoke about earlier, and instead have our permitting programs, through the use of those requirements in the permitting programs and the concepts of the new anti-dam implementation rule, provide the protections. And we should be separating those things, not commingling. So we have the same concerns with 6,500 that we currently have with 1,000.
And for some context here, the majority of permitted systems are under 1,000. There was some conversation about this during the introduction last week, but a typical residential home is 150 gallons per bedroom. So most of them are well under 1,000 for a residential home. An indirect system of 65 with a design capacity of 6,500 gallons or more per day is a substantial system. It's like a community type indirect wastewater system. And one of the things raised in testimony last week was that these lake watersheds that we're looking at as meeting the standards for reclassification are larger than some of the high mountain stream watersheds that are already class A. And some of them encompass villages and town centers. And a 6,500 gallon prohibition would create the same impediment in those town centers that the 1,000 gallon prohibition currently creates. Impediment to replacement systems or improved community types, indirect systems.
Thank you, Chair Bray. So if I understand correctly, you're making the case that the 65,000 or 6,500 gallon cap limits people's ability to fix problems with their systems? How likely is that compared to people just building bigger homes or multiple homes and being permittable?
That's a good question. And I think it really depends on the communities that are going, depending on which waters are reclassified. It depends on the communities that are going to now become part of those watersheds. Are they communities that require substantial upgrades to their wastewater systems? Or are they largely rural areas in those watersheds that just might have one-off residential development? And I think that we could maybe provide more pointed information because we have some, Bethany has information about some of the lakes meeting the criteria and the size of those watersheds.
I could speak to the number of permits that currently exist. So in our class, in the candidate class A1 waters, there are currently, because there are now B2s, 16 permits for systems between 1,000 and that 6,500 threshold. In the B1 waters, I believe it's 29. So these are systems, again, between 1,000 and the 6,500. And then for systems greater than 6,500, there are presently 3 systems greater than 6,500 in our class A1, candidate class A1, and 8 in our candidate class B1. So that's the number of currently permitted systems that would fall within those design flow categories in those candidate waters that are, roughly 140 waters.
Okay, so just so I follow along. So what I'm hearing you say is that majority of the permits are under the 6,500 amount. So now a big loss here. And of those permits that are over it, how many of them are fixing problems versus just their big homes or big properties?
We don't have that information. We can look up that information.
Yeah.
I think the
Because it's a
point that
compelling
we're,
argument, but it just feels less believable to be happening in reality than people just like building larger homes.
I think there's a mix, and I think the point really, the underlying point that we're making really is that it depends. That, you know, are these systems, what are the purpose of these systems, and are these systems appropriate for that particular watershed? And sitting here making a unilateral decision that 6,500 is the right number, depending on what the purpose is and depending on the size of the watershed. And some of these lake watersheds are fairly large. That having that number in place, I think, is still going to have that same chilling effect as we try to classify our waters based upon their condition, and dragging along with that some of a preconceived number that may or may not be appropriate for that watershed.
Well, I don't think it's I do think it is a number based in some other categories that we have, is my understanding, is the 6,500 does come from other.
It does,
It
yes.
doesn't have a relationship to water quality in the watershed. It merely has a relationship to how we administratively divide our permitting.
Okay, well, that feels not made up, and at least it feels like it was based on
No.
some position, but I guess just sorry to speak to my thought here. I guess I'm not scared of a chilling effect on very large systems on high quality waters. That feels like maybe something we don't want. But what kind of homes are we talking about? 60, is that like
It wouldn't be a
eight?
home.
It would be a business.
It would be like a school or, or like a community
Small
system
communities.
that had a number of connections.
Yeah,
to-
so like a condo development.
Or it could be a number of homes that are located in a residential subdivision or something that are all contributing
Yeah,
to a common system that, you know, perhaps
development, a large
provides better treatment.
Large community systems are also being proposed as a replacement for many individual older failing systems. That's been one of the, that's been progress that's been made as these systems have become more technically technical.
And what
Could
you're
be,
saying is that would be not able to happen.
Exactly.
Well, that feels like a compelling case, but I don't understand why you wouldn't, if it's making the water better quality, like that's the confusing part. I thought we allowed.
You'd have to be able to issue a permit for that new system. And it's in the order of around 10 homes. You can think of it roughly in that ballpark, plus or minus a few, but it's roughly 10 homes. In order for us to be able to issue a permit for that new system, that's where the prohibition would kick in. You wouldn't be able to issue such a permit for a system of that size.
Okay, it'd be great to understand that in
Sure.
reality as
And
well.
so 6,500 divided by 150 is 43.
So it'd be 43 homes,
43 bedrooms.
bedrooms.
So,
Okay, yeah.
All right, Senator.
Thank you for.
Okay, Senator Watson?
Thank you. So thank you for asking those questions. That one thing I want to pull on a little bit more, that's on that line of questions, is thinking about the outstanding resources, water resources that we have, where you can only do something if it improves the water. It's got it. So thinking about, like, are we fixing systems? Would it be acceptable to say you can do a 6,500 gallon permit if it improves the water?
The majority of these systems are not going to result in any impact to the water, depending on where they are in the watershed. They're designed as primarily as either capture or infiltration systems that don't allow any discharges to the waters at all. So in the anti-degradation, one of the first steps is reviewing whether a proposed project would have any measurable impact on the physical, chemical, or biological criteria of the water. And the majority, 99% of the time, the answer is no. The systems are not allowing any discharges to reach surface waters. They're indirect discharge systems. I'm sorry, just improving the water. So for the outstanding resource waters, one of these permits would generally, I don't imagine that we would permit a large system in an outstanding resource water. The protections on those are very strict.
Yeah.
It's just the higher quality waters we're talking about here.
Right. But just thinking about applying that similar kind of standard to, really, instead of an all-out prohibition on 6,500 gallons or more, what if it was, you've got to demonstrate that it's either not going, I mean, you said it's 99% of the time it's not going to impact it. What if you have to show that it's not going to impact it or it's going to improve it?
The showing that it's not going to impact it is, again, part of the evaluation that we would look at with the system, as Hannah was just describing. And sort of, you can think of it as sort of a three-gate system, where the first question that you would ask about a proposed system, regardless of its size, would be looking at its size in the watershed, looking at its scale to the watershed, a larger system in a much larger lake watershed, looking at its location within the watershed. Is it close to a water, or is it going to soak into the ground before it moves laterally to that water? Looking at, would it have a discharge based on those factors? Would it actually result in a discharge to that water? First of all, is it going to make it to the water? And second of all, then, even if it makes it to the water, would it result in a change in the chemical, physical, or biological characteristics of that water? Many times, even if it makes it there, it may not actually result in a measurable change. Thirdly, if it does result in a measurable change, that's when you would go into looking at alternatives. Is there a different place to locate it? Could you provide better treatment for it? Could you do these other things? So that's the proposal and how we would look at these things under the anti-degradation implementation rule. Again, rather than having a one-size-fits-all upfront prohibition, that in these higher quality waters that we propose to have this, especially for systems of that size. We can talk about this in a moment when we talk about the proposed Act 64 changes, but for a system of that size, we would have that individualized review of such a system, checking on those things.
Okay.
Because that seems like the right place to evaluate whether or not that system is appropriate.
The indirect discharge rule is a more complete analysis than the wastewater permit rule.
You could say that, yes. Certainly in terms of number of pages it is, but it's also, it gets a more individualized review by the agency in terms of those permits.
Although both are substantial permitting review processes.
Right.
Sure.
So you're not taking anything away from the on-site rule, but instead,
Yeah.
more with the IGR.
So if the result of that process was to determine that, yes, it is going to make it to the water, and yes, it is going to impact it,
Mhm.
it would be potentially permitted. If you look at alternatives, maybe there's not alternatives,
Exactly.
whatever, but it's ultimately permittable if it doesn't degrade it below the floor, right?
If you make the decision that allowing that limited lowering for that particular system, for the purposes of that particular system, and going back to that socioeconomic test.
Yeah.
That is potentially permittable if it stays within that range in some capacity.
It could be, the socioeconomic justification test requires that we find the project is necessary in order to prevent substantial adverse socioeconomic impact.
Yeah.
So we have to make that finding. It's a very high bar.
But it always would stay above that minimum
That
floor.
Right, we could only allow that limited lowering as long as it was above the class A floor for the water quality standards.
So it sounds like let me paraphrase and see if I got it. You're feeling like the permitting processes are driven by functional impacts on the waters, and that if we're going to rely on them, don't add a somewhat arbitrary threshold again to the permitting process.
That's exactly our position. Yeah, sure.
So I'm guessing that's not an entirely resolved issue, but in order, I have my eye on the clock a little bit. Let's keep going so we know if there's other things in the draft that you would like to flag.
We had some minor language tweaks in this master draft, the amendment to 1259, but we can discuss those with Mason and John later.
Sure.
I would just, in the interest of time, like to turn to the proposed amendments to chapter 64, that other documents that
The other?
Mason walked through.
Okay.
The primary focus of the proposed amendments here were to remove the statutory deference to the licensed engineer certification. One thing that the agency, the first amendment, it proposes a change to, this is 10 VSA 1973 C. And this would be when a variance from the required permitting standards can be issued for a replacement system. This is either a replacement of a potable water supply or a wastewater system. The proposal was introduced today that would not allow a variance if the system is in the watershed of a Class A B1 or outstanding resource water. The agency is opposed to this change because the language in the statute currently is a very limited variance. A variance from the permitting standards can only be allowed, the technical permitting standards can only be allowed if they absolutely cannot be met.
Or replacement
For
system, in other words,
replacement
for a system that's failed. So it's our thinking that this language would prohibit then the replacement of a failing system in these watersheds if such a replacement required a variance because of site constraints, which exist in reality.
So is this, are you saying that it might have the perverse impact of disallowing a replacement system that
Yes.
would be an improvement over a failing system?
Exactly.
That's correct.
Well, since we have everyone in the room, have you considered that interpretation of what this variance
No, I mean,
allows
that's not
for?
what we want, obviously. I was looking at it, I did not have that background information, I was looking at it as you would get a variance, you wouldn't have to meet whatever the stringent standards were. But if, I guess I'd have to check, I just want to check if that's how variance is only used. If variance only means replacing failed systems, we want failed systems to be replaced.
Yeah.
But that's just, I just didn't have that context.
So we can work with that language. Yeah.
Okay.
Yeah.
Well, avoid perverse language. Okay, onward.
The second proposal, the proposed change is in, if you just scroll down, 1973 F. And this relates to the Secretary's deference to a certification by a licensed designer. The agency would propose that the deference be waived for systems greater than 1,000 gallon design flow, rather than all systems.
These systems, as Senator McCormick mentioned earlier, the change to deference to licensed professional engineers was made a number of years ago, and the capacity of the program to be able to review all permits was the issue at hand, and this change was made in these A1 watersheds currently existing A1 watersheds for systems less than 1,000 gallons per day. No deference such as this currently exists, and the permitting process works. In exchange for, and we understand the concerns that have been expressed about lifting the 1,000 gallon per day prohibition, the agency would be able to commit to a more hands-on approach as described in this language for systems greater than 1,000 gallons per day, but we can't go back to square one and review all systems. So that would be our counter proposal there, is that we would commit to looking at, in much the same way we look at indirect systems, looking at wastewater systems greater than 1,000 gallons per day.
So then two reasons then are, one, workflow management. You would have every permit.
Program capacity is a big concern.
And the fact that the status quo currently in A1 watersheds is that the systems enjoy the deference, or, are managed through the deference to licensed professional engineers with the, with the inherent responsibilities that come with that.
Okay. Is there any process available to concerned parties if they have a perception that one or more systems proposed by any particular engineer is inadequate. Like, is there a way to ask for a review of the work of an engineer?
Like a process available to neighbors that might be concerned, or an applicant who had requested those consultation services of an engineer.
Well, I'm being polite and a little too vague. To be more direct, I've heard stories that there are, it reminds me a little about getting an inspection sticker for your car. There were places to get an inspection sticker for your car that you could pass. But if you went to someone who was more strict, you weren't going to get your sticker. And people would know who to see in order to pass inspection. The sort of anecdotal stories I've heard, not just in the last 6 months, but over the years, is there are professional engineers to whom we might go that will be more permissive in the way that the system is designed. And so people wonder why, how that passes muster. So I'm wondering, is there any process that lets an individual or organization say, we have a concern about the work of this particular shop, and that you would then examine the designs that come out of that shop?
Two responses. The agency does a lot of over-the-shoulder review in our review of these permits. So the agency has an idea of the type of designs that are coming out of individual shops. The engineering licenses are issued by the Office of Professional Regulation, and there is a process available through that office when there are questions about the professional work of any particular individual that has a license issued by them.
Okay, so the regular OPR review.
Yes.
And do you happen to know, I mean, this is not a question you would need to know the answer to, but maybe you do. Do you know who is allowed to go to OPR and raise a question?
I don't know whether that's open, whether that process is open to the public, although I imagine that it is, given that the regulated
Right,
public.
sort of consumer protection really
Yeah.
is the heart of it.
Mhm.
Okay. Well, thank you. So let me check with Mr. Mason et al. The proposal, as I hear it, is that this provision would add the caveat that it's only for systems greater than 1,000 gallons.
I've learned from my good friend Mason to say that we like to think about it.
That's right.
Right, did I get that right, Mason? But I learned for myself that I'll say, yeah, I understand what you guys are saying, but we want to think about it.
Yeah.
But it's rational distinction, I think, that you're drawing here. But yeah, we just why don't we chew on it, and then we could look at the language and talk about it.
I'd like to see it. I'd like to see.
Sure, yeah, but maybe at the same time, I can pull it, but look at the variance language and how that works.
Yeah.
You know, if there's context for that, you can just do both things. Sure, but I see what you're saying. Appreciate, the willingness to, to move towards, what we're saying. But yeah, let's just think about it a little bit.
Okay, great. Yeah, I don't mean just putting you on the spot like
Yeah.
answer, but I'm just trying to test the waters a little bit.
I just wanted to impress Mason that I learned.
Lord's lawyer.
Right, so anything else? Kristen?
No.
Okay, great. So I'm looking at the clock, we're perfect timing on all this, so
Well
let me
done.
propose a schedule, and that is, can parties discuss this and come back with a draft tomorrow by what's a reasonable time? Close of business, noon? I'm looking for you to see but I'm trying to say if we could get a draft back so the committee will have an opportunity to receive it and read prior to reconvening on this on Friday morning.
Tomorrow. We're available.
Yeah.
Yeah.
Yeah, I'm tied up, but I'll make it happen.
Yeah, definitely. I mean, I had meetings until like later in the afternoon today. I'm totally free tomorrow.
Could we do this offline, maybe?
Yeah,
We're gonna plan some-
well, I'm just letting, I want to
Noon
let people know
tomorrow,
we're
or
following.
after
We're
that?
gonna be back.
So by noon tomorrow.
Okay.
Would that
Great.
be
All right,
acceptable?
so by noon tomorrow, and if you can send that to Jude, and the committee, we'll get it posted and distributed directly by email, so that everyone will be off their afternoon committee, but you'll get an email with it. And then we'll reconvene. I'll just nail down the schedule for sure, but I'm looking at 9 AM on Friday morning. And we'll have a block of time to sort our way through and maybe get to yes all the way around. Okay, great. So thank you everyone for really for great attitude and work effort. Like I feel like we're making progress, and we are, unless there's any other committee questions, concerns, new business,